Hi, I'm Shashank Bhargava, and you're listening to Three Things, the Indian Express news show. In this episode, we talk about the renewed interest in lunar exploration and what scientists are aiming to achieve. We also talk about the ongoing no-confidence debate in the Lok Sabha and Rahul Gandhi's inaugural speech. But first, we talk about India's data protection bill. Yesterday, the Rajya Sabha passed the Digital Personal Data Protection Bill 2023 with a voice note after members of the opposition walked out over the ongoing Manipur issue. The bill was passed by the Lok Sabha on Monday and will become a law once it gets the President's assent.
Honorable Chairperson, ma'am, I rise to move that the Digital Personal Data Protection Bill 2023 be passed.
Motion moved that the bill be passed. The question is that the bill be passed. Those in favor will please say aye. Aye. Those against will please say no. I think the ayes have it, the ayes have it, the ayes have it. The bill is passed.
Now, this was India's second attempt at framing a privacy legislation, and it comes after 3 previous iterations. As many of you might recall, in the previous versions, privacy experts had raised concerns about the kind of exemptions it gives to the central government. The current bill not only retains many of those exemptions, but also gives the centre censorship powers. In this segment, we are joined by Raman Jit Singh Chima to talk about this bill in detail and the concerns it raises. Raman is the Asia Pacific Policy Director with the international rights organization Access Now. Raman, could you begin by telling us how long this data protection bill has been in the making?
The Minister for Information Technology and Telecom, Ashwini Vaishnaw, talked about it being 6 years in the making, but it's actually much longer. Attempts to create a privacy law at the federal level in India, including looking at data protection, has actually been in progress since 2009. So it's been across, in fact, different political parties, multiple administrations. And what you see in effect is now nearly a 13-year journey into creating a federal privacy and data protection legal framework for India, noting that India is perhaps one of the outliers which does not have any clear federal law regarding privacy and data protection, that even factoring into account the fact that the United States is perhaps the most notable exception because it doesn't have a federal data protection law, but still that has some federal privacy law. We have had none. We now have one. It's not a great one.
Right, and we'll get to the concerns in a minute, but the whole idea behind a bill like this is to protect the personal data of individuals and establish a data protection authority that would hold companies, governments, and individuals responsible if they violate someone's privacy, if they use or collect data without consent, and also don't inform them about what their data will be used for. And this is just for the benefit of our listeners. It gives people the right over their data, be it personal data like their name, age, or location, or sensitive information, for example, related to their health or sexual preference. Because right now, like you mentioned, there are no laws that tell companies and entities what to do. So tell us the extent to which this bill safeguards these rights, or at least claims to do that.
It claims to, and it seeks to try and say that when you collect information from people, it must be with their consent. There must be informed consent. So you must know what your data is being collected for what purpose you're supposed to offer. And the bill tries to say that it should be made available to you even in your local language, a point that the minister and the government's has invested a lot of time in emphasizing in communications to the public or in parliament. And in fact, it says that when other entities are doing this, they need to keep records of how they're collecting this consent, of what they're doing with the data and what purpose it's for. It's the concept of purpose limitation. Unfortunately, this law is a little bit weak on that compared to other global laws, but it has some basic elements of that. And what that means is today, if someone's collecting information about you, you have a right to know that. You have a right to know what they're collecting it for, and they have to take your active consent. They have to tell you who is potentially accessing that data, where is it shared with, and you have certain rights there. The right, for example, to access your data, the right to delete your data if you believe it's no longer up to date or valid, and then the right to seek other forms of your personal preferences on this data as well. And that in some ways is perhaps transformative. You already have different forms of these rights in India, including sometimes the right to information or other parts of rights provided by courts. Looking at Article 21 relating to your right to life and liberty, as well as your other protected rights. But this law creates a clear statutory framework for your rights regarding personal data, as well as the regulator you go to. Unfortunately, in practice, because of the way it's designed, it's much weaker than what other countries' legal frameworks are regarding personal data. But it's a slight evolution on India's at least statutory process for that. And when I mean statutory, I mean the law passed by Parliament, not just the law as outlined by judges when they look at these things case to case.
And under this bill, how will a company be penalized if they break the law, if they violate someone's privacy or misuse their data?
So what the law does is it says that any person, and that's an important, very specific detail, any person can complain about the data protection, the Digital Personal Data Protection Act being violated, and can bring a complaint to the Data Protection Authority. The authority is supposed to hold an investigation, conduct a hearing, and then come to a conclusion. They can direct that entity to do or not do certain things. And that entity, by the way, is not just firms, it can also be individuals, which is one of the more problematic parts of this law. And then it can tell an entity or an individual to do or not do certain things with that data, delete that data or don't do a certain practice, but then also penalize them with financial penalties. And those penalties can range from a few lakhs to, in fact, several lakhs to crores. And that is one of the changes in the law, perhaps in response to criticism, that it was watered down to perhaps go easy on corporate entities. So it does allow for penalties up to perhaps 500 crores, if I remember correctly from the schedule to the bill. Of course, it's very telling that in other countries, that penalty figure is up to a much higher threshold. For example, the European Data Protection Framework allows penalties of, if I remember correctly, nearly 3% of global turnover of a company, which is sometimes the level of penalties you need in order to discourage big tech or large corporate interests from misusing data.
And the bill also states that if an entity is penalized on more than 2 instances, the government, after hearing the entity, can decide to block their platform in the country. And this is a new addition to the measure, which was not present in the 2022 draft. What stands out to you about this provision?
It's quite a concerning provision. And as you noted correctly, it wasn't there in previous drafts, nor in fact is it actually there in any other data protection law from major democracies in the world. Yes, sometimes what regulators do in many countries is somebody fails to comply, they can force consequences on the entity. They can take temporary measures to prevent data from being misused. For example, if someone is actively breaching people's data, they can say you must order specific blocking or very limited restrictions on that. But that's a very limited exceptional case there. What the Indian data protection law has essentially done is create a web censorship power in a data protection law, in a law relating to personal privacy, and say that if someone is repeatedly not following the fines or penalties, the central government can, after speaking to this regulator, the data protection board that the law creates, order the blocking of that content. Now, this may seem innocuous because it's just saying it's for repeated instances. The problem is, as you know, repeated instances can quickly escalate when the government is having a disagreement with a private firm or with any entity. And here, for example, what if that entity is, say, a news group? It's a newspaper or a journalist group that is collecting data they believe is completely valid, but the government is gotten into a dispute for political reasons or for other reasons with that entity, issues one fine, issues another fine. And even as those actors are perhaps challenging those earlier penalties in court, the government can go ahead and order the blocking of their content directly. And what's particularly troubling for me, of course, is this is happening in the context where over the last 2 to 3 years, we've seen an explosion of web censorship blocking orders issued by the government of India. Not just internet shutdowns, for which India is also unfortunately the world's #1 leader, but even in terms of the number of hundreds of requests of blocking Twitter content or blocking content on different social media, blocking entire accounts or handles of actors. The federal government is doing that under a legal process that's already very unclear. And this process makes it worse because if you notice, it says that you can do this, but you don't have to go to a judge to get this permission. So in effect, it's the central government perhaps talking to the regulator, and the regulator is also in effect appointed by the central government. And this purely executive branch process gets to determine something that could block entire services in very troubling ways, or as I mentioned, block even specific news outlets, not-for-profits or others who are operating in India.
And could you just elaborate on this? You mentioned the control of the center in appointing the members of the Data Protection Board. Talk about how this will affect the entire process.
As many people might be familiar in India, an independent regulator is only as good as the people appointed to that body, but more importantly, the process of appointment. You can create a very well-defined, well-structured, well-funded body, but if it's the central government that gets to choose exactly who's on it, no matter which party is in power, they can determine, if, in effect, the direction of what that regulator does. And unfortunately, this is a consistent issue with the data protection bill, which will perhaps now become an act in the form that it's now being pushed through Parliament. Namely, it lays out criteria for who can be on the board. It makes some notional improvements on the powers and the functioning of the board. But it is very clear that the central government appoints the members of the board. There is no qualification on, say, consulting members of the judiciary or the leader of the opposition, the single largest party in the Lok Sabha or the Rajya Sabha, or other independent actors. It is, in effect, the central government that shall appoint these people. And that is the fear here, that when you have this sort of appointment criteria, in effect, you have a data protection board that is appointed by the central government. And remember, the central government itself is the largest data collecting entity in India in many ways. And perhaps it's the largest public sector entity collecting data. So, in effect, the largest target and the largest entity sought to be regulated by the Data Protection Board is getting to choose who is on the regulator itself.
And Raman, almost a year back, the government had suddenly withdrawn the data protection bill. And that time, one of the concerns had been that it gives blanket exemptions to the central government. The earlier version had said that for national security reasons, certain agencies could be exempted from some of the provisions and the adverse consequences of the bill. Is that still happening with this version?
You're right that the bill was deeply criticized on the fact that it granted large exceptions. And particularly, that is something that brought up by citizens groups, by public interest groups, by global data protection experts, also by other governments, including governments who try to send data to India or who are in charge of regulating data sent to India. And we can talk about that later, but it's important to remember that India is in the center of a global web of data flows across borders, subject to other countries' data protection laws. So those countries also want to have an interest in making sure India is matching their standards. But what we've ended up today is what I would regard as a small edit rather than a rethink. What they've done is, instead of using broad sections like calling something deemed consent, where they said that if you give data to perhaps the government or entity set up under passed by the government or by state assemblies in India, and you can imagine that's so broad, right? That could be anything from, say, the Delhi police to the Waqf board of X state to X entity. They would have deemed consent to access your data, and they would have been deemed consent even to things like credit scoring, all those annoying messages and phone calls we get where people are trying to build histories of our financial data. The government would have given them a carte blanche. And the government has reduced a few of these cases, but they've actually just rebranded the section. Rather than calling it deemed consent, because they knew that's a phrase that perhaps globally doesn't work. Every global data protection expert was saying that's horrifying what India is proposing. They just retitled it as limited exceptions. So they said, here are certain limited cases where people can collect data and share it without consent. And that's what they mean there. And I think what's most alarming, as I mentioned, is these blanket exemptions given to essentially the public sector. If you're a central government agency or even an instrumentality of the state under the language used by this law, you perhaps are exempt from requirements of seeking consent over data collection, data sharing, or people being able to apply data protection rights to the data you collect of them. And that's extremely alarming.
And when we talk about exemptions, are they mainly in the interest of national security, like the government had claimed earlier?
No, they're quite broad. They're not just national security. In effect, as I said, they sometimes say even if it's just the collection by entities set up by, say, statute or that are public agencies, and they've used the broad language of that sometimes they're in Article 19.2 of the Constitution, friendly relations of foreign states, security of public order, or other matters. They're quite broad. We've heard the minister responsible for introducing it through Parliament, Minister Vaishnav, say that, for example, we have fewer exceptions here than what exists in Europe's General Data Protection Regulation. That's partly true, but it's also misleading because those exceptions are more numerous in the EU GDPR, but they're much more specific language. Here we've given much more blanket carve-outs under one or two clauses instead. And what's also alarming there is the sort of national security, or you could say government interest exception we provided is so broad that it actually is perhaps more broad than what any other country in the world does. In effect, what this does is it puts India's global multi-billion-dollar outsourcing industry directly in the crosshairs of activists or others who may bring challenges. But more importantly, it just is not a good enough legal framework, even for the data of Indians whose data is being collected by corporate or government entities.
Right, and Raman, earlier there had also been concerns around data localization, storing the data of citizens inside the country. Earlier, the government wanted tech companies to store a copy of the sensitive personal data here in India and said that certain critical data should not go out of the country. And it had not defined exactly what this critical data was. And the impression was that through this, the government basically wanted access to users' data. And tech companies didn't care for it because for them, storing data locally was just an added cost. Is that still a concern with this bill?
So in effect, what you can see is a compromise in this law, but it's a perhaps alarming compromise. And I say the people most impacted negatively are citizens. Yes, as you mentioned, there was a provision in this law saying that if data was to be taken outside the country, either a copy of it would be stored here, certain data would not be allowed to be transferred. And it might seem like the government's acting in the public interest there. And in fact, the answer is no, as the government was trying to keep data in the country so it could access it. Or it said that if data goes to other countries, we don't mind so long as our law enforcement can access that data. And that's actually quite a perversion of the global understanding of data protection, which is that if I am an individual, my country has an obligation to protect my data protection rights no matter where the data goes to. That's what, for example, EU citizens or citizens in Australia, United Kingdom, or Canada, that's the sort of like rights they benefit from. Their government is under that obligation. Our government said, we don't really care about what other countries do with the data so long as we can still access and snoop on that. So it's actually a perversion of the concept of data protection. And what you see in this law, what they've done is they've removed data localization as an express obligation. They've still given the government the option to blacklist data transfers to certain countries or to put pressure there. But in effect, what they've done is they've lowered standards everywhere else. So what that means is the government can still keep and collect its own data. Yes, it may not be able to compel private providers as easily as they were perhaps going to be able to do so under earlier versions of this law. But in effect, it's a lowering of standards for everybody. So some parts of, say, the global tech sector are happy, the government is happy. Unfortunately, for individuals and impacted groups and vulnerable communities in India, I would say that they should be very concerned, if not unhappy, on where we've landed.
Raman, what are some of the other things that stand out to you about this bill, especially when it comes to issues of surveillance?
So concerns about surveillance have been brought up from day one of this bill being brought, not just to Parliament being considered. And even in the passage of this bill, the Rajya Sabha, during our opposition walkout, which meant that the only parties there were the government or parties supporting the bill, even then concerns about surveillance were raised, for example, from members of the YSR Congress Party, saying, how will this bill address the issue of surveillance, of spyware, and of targeting of individuals? And in effect, the government's response was to, again, just deflect it and say, don't worry, whenever surveillance happens in this country, it happens under a rule of law framework and is perfectly necessary and proportionate. It's in fact the government using all the right buzzwords, but giving no promises and no commitments. And it's very alarming given that the government's own advisor on data protection, Justice B.N. Srikrishna, a former Supreme Court judge, the person who headed the committee set up by the government, has categorically said that the current data protection law is so weak that it actually encourages mass surveillance. And stepping back for a moment to the government's data protection committee itself, which remember was not just Justice Sri Krishna, they're serving government members on that committee. That report was very clear. It said Indian data surveillance or data access powers and practices are in fact likely unconstitutional and beyond what is acceptable in India now, given the Justice Puttaswamy ruling on the right to privacy being a fundamental right in 2017. It said that India is behind global practices and is in fact again in breach of its own constitution potentially. And despite all of those explicit warnings and reminders and all those concerns, the government has done nothing to address the issue of surveillance in this law. In fact, they have tried to codify a massive backdoor for themselves and said that any data collection by public sector entities will be protected under this framework. It will not be challenged. So rather than actually make the situation better for surveillance, it's sad for me to say that this law actually seems to codify that weakness perhaps for a decade or more, or until we are able to reform or see challenges to this law.
And next we talk about the moon rush. This week, India's moon mission Chandrayaan-3 entered the lunar orbit and is scheduled to make contact with the lunar surface by the end of this month. If it manages to make a soft landing, then India would become the fourth country in the world to have done so. Now, India is not the only country that has sent a spacecraft to the moon this year. Russia's Luna 25 is currently in the middle of its final preparations for its upcoming journey. Scheduled to commence later this week, the mission is expected to achieve its lunar landing around the same time as Chandrayaan-3. And besides Russia, even Japan is set to launch its own mission to the moon at the end of this month. Now, although this interest in lunar exploration is not new, the moon is on the verge of becoming a much more frequent destination. Recently, Indian Express's Amitabh Sinha had joined Nandgopal Rajan on an episode of Our Own Devices, and he explained why this was happening.
So the current round of moon probes, which can be traced back to the 1990s, that we started sending orbiters to probe the moon all over again, this current round is qualitatively very different from what we tried to do in the 1960s or what the Apollo achieved in the 1960s and early 1970s.
Here, Amitabh is talking about the period which had witnessed an intense rivalry between the United States and the Soviet Union in their quest to conquer the moon. This rivalry is what culminated in the historic landing of Apollo 11 in 1969, a mission that marked humanity's first steps on the lunar surface.
So at that point of time, yes, landing human beings on moon was a huge, huge technological leap. I mean, it's unimaginable the significance of the achievement that was done in 1960s. It would also become more clear if we realize that space age had begun just about 12 years ago. So in 12 years from sending the first satellite in space, we landed human beings on moon. I mean, it's a super fast kind of technology development.
However, Amitabh says that after 6 Apollo missions, which had successfully transported a total of 12 astronauts to the moon by 1972, lunar exploration came to an abrupt halt.
Once we did land on moon, in itself it was a huge achievement. But having done that, there was little we didn't know what to do ahead. I mean, what to do more and how to take it forward. And that was mainly because, the technology ecosystem that would have allowed us to take the benefit of that landing, that achievement, and expand it to do something much more than that. That technology ecosystem wasn't available. So we carried some of these stones and everything, and which kept scientists busy for quite some time, just trying to figure out what is the mineralogy of the moon and all those sort of things. But we didn't know what to do next after that. And suddenly, that's why you see after the last Apollo mission, there is a complete lull for about 2 decades. And suddenly we start seeing this again, starting from the early 1990s. NASA sent some probe missions to moon. And then after other countries also joined in, we sent our first Chandrayaan mission in 2014, sent the second in 2019, which failed to land. But yeah, I mean, it did, the orbiter functioned quite well. And now we are sending third. And in between, lots of other countries have also sent. China has managed to make a soft landing, not humans, but the orbiter, the lander part. So there is a renewed mission interest in moon. And this time, as I said, it is qualitatively different. We are going to moon not just with the objective of landing, but using it and using the resources available on moon to do something more.
The more that Amitabh refers to here is essentially deep space exploration, which involves using the moon as a launch pad to venture further into space.
And there are certain reasons to do that. One, of course, the gravity on moon is, of course, not as strong as on Earth. So if we spend a relatively little amount of energy in launching our rockets from moon, it would go much deeper than the kind of energy that would be required on Earth. So it makes a lot of sense for us to start launching from moon. But launching from moon, it's not a straightforward exercise. You have to build the facilities, and that facilities again would also require a lot of brick and mortar, isn't it? Not just space tech and all. And carrying all of that from here to moon to create a permanent facility, a permanent laboratory, a permanent launch station at moon, that again doesn't work out economically. So the idea then is to use the internal resources of moon in situ, whatever resources are available, use that to build a permanent research facility on moon, and then use moon to launch human beings much further into space. And the difference from the previous time and now is that now we have the technologies available to do that. It's possible now to be able to use the moon's resources, build things using the resources available there. You don't have to carry a lot of things from the Earth.
For example, let's consider fuel. Transporting fuel from Earth to construct stations on the moon would be quite a costly affair. Therefore, it would be highly advantageous if these resources could be located on the moon itself. In fact, Amitabh says that this is one of the reasons that scientists became excited when water was discovered on the moon, because it implies the existence of potential energy sources on the lunar surface.
So if we are able to extract hydrogen from the water molecules, then that's the ready-made fuel that we have, which we can use to power our facilities, which we can use to launch our rockets much further and send much deeper space probes from moon. So that is the whole thing that is unveiling in front of us right now. It's not just about going to the moon, but using moon to go much further.
Now, this new era of lunar exploration could potentially spark the same kind of competition between countries that the world witnessed back in the 60s and the 70s. And this competition could revolve around lunar resources. But Amitabh says that there are international agreements in place to ensure that this does not happen.
It is supposed to be global common, wherein you don't own it. You can work around, you can utilize the resources, but you actually do not own it. And there are already international agreements in place. Recently was in news as well, the Outer Space Treaty, when during Prime Minister Narendra Modi's visit to the United States. So the Outer Space Treaty actually does exactly that. It's a sort of a common agreement on what is good behavior in space, so that you don't take each other's assets out, you don't attack each other, you don't own anything, but you can utilize the space and you can use the resources and can place your satellites and those kind of things. So Outer Space Treaty is a general treaty, and there is one very specific treaty, which is a follow-up to the Outer Space Treaty, which is called the Moon Treaty. Now, Moon Treaty is very specific about what you can do on Moon. Outer Space Treaty has been signed by most of the countries, spacefaring nations. This Moon Treaty, not everyone is signatory to it. And crucially, the United States is not a signatory to it. So Moon Treaty is something which talks about what you can or cannot or should not be doing once you are on Moon. There would be no ownership, that this is common, that all the things would be collaborative, and that fruits of research or the fruits of whatever we get once we are on the Moon, fruits of the resources, that would be common sort of wealth of the entire globe. So we have specific arrangements on that. Now, of course, this is still contentious. It's not a settled issue, but the resources as envisaged is global common property.
And in the end, we give you an update about the no confidence motion debate in the Lok Sabha. Yesterday, during the ongoing debate, senior Congress leader Rahul Gandhi made his first speech in the parliament after the Lok Sabha secretariat cleared his return on Monday. This was done after the Supreme Court stayed his conviction in a 2019 criminal defamation case over his remarks on the Modi surname. During the debate, Gandhi launched a scathing attack on Prime Minister Narendra Modi on the Manipur issue, saying that BJP's politics has murdered India and Manipur.
Speaker sir, इन्होंने मणिपुर में हिंदुस्तान की हत्या की है. आपने मणिपुर के लोगों को मारकर भारत की हत्या की है. आप देशद्रोही हो. आप देशभक्त नहीं हो. आप देश प्रेमी नहीं हो. आप देशद्रोही हो.
The Congress leader also slammed PM Modi over the recent clashes in Haryana's Nuh district, saying from Manipur to Nuh, you have set the entire country on fire.
आप पूरे देश में केरोसिन फेंक रहे हो. पूरे देश में आप केरोसिन फेंक रहे हो. आपने मणिपुर में केरोसिन फेंकी और फिर चिंगारी लगा दी. अब आप हरियाणा में कर रहे हो. पूरे देश को आप जलाने में लगे हो. आप पूरे देश.
During his speech, Gandhi had said that the BJP is responsible for harming Bharat Mata, which was later criticized by BJP leader Smriti Irani.
संसदीय इतिहास में आज तक भारत मां की हत्या की बात करने वाले कभी भी बैठकर मेज नहीं थपथपाते. कांग्रेसियों ने बैठकर मां की हत्या के लिए मेज थपथपाई है.
Now, minutes after Rahul Gandhi wrapped up his address in the Lok Sabha, Congress General Secretary Jairam Ramesh claimed that the Sansad TV, the only parliamentary channel of India, focused on Lok Sabha Speaker Om Birla for 70% of the time during Gandhi's speech. Ramesh said that Rahul Gandhi spoke for 37 minutes during the no confidence motion, out of which the Sansad TV camera showed him for only 14 minutes 37 seconds. Also, the no confidence motion debate yesterday took an unexpected turn when some women MPs from the BJP launched a complaint against Rahul Gandhi for allegedly blowing a flying kiss in the parliament.
ऐसी गरिमा विहीन आचरण को इस देश के सदन में कभी नहीं देखा गया.
The complaint, which was lodged to the Speaker Om Birla, was signed by more than 20 women parliamentarians seeking stringent action for the inappropriate gesture. Members of the opposition parties came out strongly against these allegations and criticized Smriti Irani for diverting the issue away from Manipur.
ये भारत का सदन है. आपकी नौटंकी का अखाड़ा नहीं है. अपनी बेकार की एक्टिंग और झूठा आक्रोश बंद कर दीजिए. मणिपुर पर बात हो रही है, हर वक्त मुद्दे से बरगलाने की, मुद्दे से भटकाने की कोशिश बंद कर दीजिए। दम है तो मणिपुर पर बात
The no confidence motion debate is expected to continue till Thursday, when Prime Minister Narendra Modi is expected to give his reply. You were listening to Three Things by the Indian Express. Today's show was edited and mixed by Abhishek Kumar and was produced by Utsa, Sarmin and me, Shashank Bhargava. If you like the show, then do subscribe to us wherever you get your podcasts. You can also recommend the show to someone you think will like it. Share it with a friend or someone in your family. It's the best way for people to get to know about us. You can also tweet us at Express Audio and write to us at podcast@indianexpress.com.